116. SB 9. Secretary, please read.
Senate Bill 9 by Senator Yee, an act relating to sentencing.
Thank you very much, Mr. President and members. This measure is coming back from the Assembly on a concurrence vote. The bill passed this House last year and is now, as I indicated, back on concurrence, but in a stricter form. The amendments that were taken in the Assembly further restricts the bill, narrows the bill. What this bill now will do is to exclude cases where the victim was a public safety official or torture cases. What this bill will do is to provide youngsters who are in prison for the rest of their lives on an LWOP sentence a second chance at life. And the provisions are already strict. The individual has to serve at least 15 years before any consideration whatsoever. The case is returned back to the court that sentenced this particular individual, and the youngster has to demonstrate that, in fact, he has accepted responsibility, he's been rehabilitated, gotten an education, show remorse, demonstrate that he or she has a system of support when he or she eventually may then get released from prison. And so this is a very clear case where individual has to make amends, accept that responsibility, demonstrated that they are not going to re-offend. And then one other point that I would say is that all of this is because there is a preponderance of evidence that suggests that young individuals are very different from adults. In the Supreme Court case, they have demonstrated and they argue and they have opined that youngsters are, in fact, very different than adults, particularly in terms of brain development. I know as a psychologist that young individuals think very differently. They are very concrete rather than abstract. And those thinking processes and those brain development causes individuals, when they're young, to be far different than adults. And given that, there is a high probability that these youngsters, as adults, will behave more appropriately within the law, and with that, urge an aye vote.
Thank you. Senator Anderson.
I rise in opposition. I want to thank the author, though, for taking those amends. I wish he had taken some additional amends to address the fact that these child killers, there's no provision if they murdered a witness. So they're a gangbanger. They're 15, 16, 17 years old, and they murder a witness, and now we're going to give them another chance at life on the streets to murder yet again. If they murdered a child, there's no exception for that. So while we've made an exception for law enforcement, we have done nothing to protect children from children killers or from witness killers. You know, I believe that we should be compassionate, but the compassion needs to fall the correct way on the victims and the victims' families, not on the perpetrators. I get your point that their minds are not the same as other criminals. They've only grown up to learn this, and they've already at an early age showed that they cannot survive in society without harming others. This is absolutely outrageous that we're going to release these little psychopaths back into the streets to yet murder again. I urge a no vote.
Senator Vargas.
Thank you, Mr. President. I stand in strong support. Obviously, we just heard words of psychopaths and other words for some of these young men, and I believe they're all young men, that have either committed murder or were convicted of murder. One of the things that's interesting about murder is an intent crime. You have to have malice. You have to have intended to kill. You have to have at least some recklessness. But there is an alternative way to be sentenced. And that is if you are an accomplice or if you're part of the crime. California has the felony murder rule. You may not have had any intent whatsoever to kill anybody. In fact, you may have gone out with your friend or your brother or your sister, and unfortunately they committed a crime, and that crime was a felony and led to murder. However, you too you too become responsible for that murder because it was in the commission of a felony. Many of the young men that have life without the possibility of parole were not the killers. In fact, they were either accomplices, they were the brothers oftentimes of the person who did murder. And interestingly, some of the cases, you even have a situation where a 15-year-old really didn't know that there was going to be a felony, but unfortunately it turns into one, and he then becomes a child that has life without the possibility of parole as a sentence. Never the opportunity ever to get out of prison. This bill at least gives them a small sense of hope that they can change their life, turn their life around. One of the things that we believe in, I think, as Americans, are second chances. And who, if not children, do we give second chances to? So I would hope that we would have it in our hearts today to give some of these kids a second chance. Oftentimes, they didn't get a chance at home, they didn't get a chance in their neighborhood. And yes, your environment does make a difference. So I hope that we can muster up the strength, the courage today to pass this bill, to give it to the governor, and that he would sign it. I would ask for your aye vote. Thank you.
Senator Wright.
Thank you, Mr. President. Members, I rise in support of this bill. Coming again from an urban area, juxtapose my colleague who spoke earlier about a rural area, there are circumstances that are probably foreign to many of the people who are here. But if you lived in some parts of my district and you're 12 years old, your survival depends on your participation, perhaps, in a gang. Your survival depends on your participation in the gang. And members, I'll tell you, gang members have actually become a little sophisticated, and they know, for example, that a 12-year-old, 13-year-old isn't going to get the death penalty. And so what you'll often see taking place in urban areas is 12-year-olds become the persons who carry out some crimes. Often, it's at the risk of their own lives. So you are a 12-year-old young man, and you live in Compton, and someone says to you that if you don't kill that person, that I'm going to kill your family. You have no way of proving that because there was nothing written down. The person who ordered you to do it understood that you wouldn't get the death penalty because at 12 you're not eligible for the death penalty. What I like about the attempt in Senator Yee's bill is that we recognize that all crimes are not the same. And I think everyone here who said that the idea that you killed someone and you can't bring that person back is absolutely correct. And I don't think that we should make light of the fact that a life was taken. But I would suggest to you that if you had a 12 or 13-year-old who committed such a crime, do you say, I'm going to put this person in jail for the rest of his life? I think you do want to attempt to make some determination, and there are some who absolutely ought to be there. They ought to be there because they're incorrigible and they're not going to get any better. And I would hope that some courts will look and try to make that determination. But I would suggest to you again, members, is that at 12, 13, 14 years old, depending upon what it was that caused the crime to occur, you want to try to look at that and make some determination as to whether or not the person who committed the crime was acting out of his own view of the world or whether or not he was coerced into it, whether or not he was driven to it. And again, it's not to make light of the crime. You know, probably unlike most of you here, I've actually seen people killed on the street. It's not a pleasant thing to see someone's life taken from them, whether or not it's by a gunshot or a stabbing. But what you want to do is consider the circumstances of that act. Recognizing something again, that when you put this person in jail for the rest of his life, you now create a second set of circumstances because now you have a person in prison with no hope. So what stops him from being the person in prison? Because now you shifted what happens, it becomes a new dynamic. Since that person has no opportunity to ever get out of prison, what's to stop him from committing crimes in prison? When you remove all hope from someone that you place in the prison system in California or any place else, that person has no discouragement. He has nothing to hope for. So what stops him from killing a guard or another inmate? he becomes the person who ends up with that challenge. So I think what you want to do is at all costs, you want to make sure that you have some level of hope, and you want to make sure that you have some level of public safety. The challenge here, members, and it becomes an equation that I think we have to measure, is that choice between public safety and revenge. Revenge is very expensive. Public safety is something that we can afford. And I think that as we look at these young men and women who've committed heinous crimes, we don't want to belittle the crime. We don't want to say that the victims didn't suffer. But as you look at those individuals and you decide what happens to them, is what you're placing on them public safety or revenge. I submit to you that the whole purpose of our criminal justice system is not revenge. God forbid that it would be, because then you would go back to what was in the Old Testament, and it would be an eye for an eye and a tooth for a tooth. And I think a wise man once said that if we practice that philosophy, before long you'd have a whole lot of blind, toothless people. I would hope that we would vote for this bill and allow the court some discretion to determine which young people should be eligible for what. How much time should they spend? Had there been some level of compassion and solace sown by that person? And it may be that there's some people who, you know what, they need to stay there, and that might be the majority of them. But I think you want to extend some level of hope for a younger person who may not have been clear what they were doing, the consequences of what they did. I would ask for an aye vote on SB 9.
Senator McLeod.
I am in full support of this bill, but that does not take away my compassion for those who have been killed. But who amongst us here, who are parents, can say that our children have behaved well in all their lifetimes? Children go out and they do, as we say in Spanish, tonterías, which is that they do very, 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 very dumb things. And we all know, as Dr. Yee says, that the youngster's mind is not like yours. But really, which of us can say that our children have not gone out and done something that we said, oh my God, why did they do that? And you know, I have talked to some of these young people that have done some crimes, and I said, in your mind, have you ever thought that you were going to hurt someone else? And they always answer no, because oftentimes they go out and they do very stupid things. And again, that is not to take away what they have committed was not atrocious, was not harmful, because not only does that family that was affected by the crime that was committed, but also the family by the perpetrator. And it goes on forever and ever. It never goes away. I had my son-in-law killed by a youngster, but I never thought I wanted revenge. I thought, what a shame. Not only was one life taken, but another family's whole entire life, for as long as they're alive, that family is also hurt. Thank you.
Senator Anderson.
I agree with so much of what you've said so far. You know, I don't want revenge, but I don't want to go through the sadness of losing somebody where we could have protected them. Our job is to protect the innocent. And if that's truly our job, then let's talk about who these people are. If they were 18 years old, with the penalty, with the crimes that they committed, they would have been up for capital punishment. They would be on death row. It's a capital punishment to kill a witness. These are not two kids playing and one kid falls and dies. This is not the types of crimes that we're talking about. We're talking about serious crimes where we have young people who are flat out evil. And to put them back into society and put other people at risk. You know, if you were saying that you wanted to make them your neighbor, I'd be all saying, well, that's your choice. But don't make them my neighbor. Don't make them one of my constituents. Because I've seen the crime that they've done. I've seen what they've accomplished. You know, we had a witness who talked about how they took a hammer to an elderly man and hit him 52 times in the head. When they captured this criminal, he had a bone chip the size of a quarter on his chin still. These are evil, menacing people. If I thought they would be safe to be brought back into society, I'd be on your side. But you know, we have a lot of advocates who say we need to get rid of the death penalty because we have life in prison and we don't need the death penalty. So here we are today with life in prison, and already we're chipping away at those protections. So I just want the Californians who are watching this debate to understand we're going to have that very same debate once capital punishment's eliminated and we have life imprisonment, and we're going to be talking about releasing Charlie Manson. These are mini Charlie Mansons. And I just can't support this, and I urge that you vote no. These are serious, serious crimes. I don't want revenge, but I don't want any more victims.
Senator LaMalfa.
Thank you, Mr. President. I also rise in opposition. You know, we talk about compassion, and we talk about how the person convicted, that they're out of hope, that their life is over in prison. That is indeed sad, very sad. But we're not talking about the euphemism misbehaving with the conviction that they have. We're talking about murder. And for the person who is the victim of that, it's over permanently. There's no option. There's no coming back to life once that person's out of prison. We understand that. It's over with. The pain is forever for their family, their loved ones, and of course for that person who's now maybe in a better place, but certainly not at their choosing. This isn't just misbehaving. It's a very heinous act. Murder. Permanent. So we're talking about needing discretion. Well, first of all, the voters of California voted some years ago to narrow the discretion when they voted for Proposition 115. So we will be defying the voters once again with the actions of the state legislature. But let's talk about the process a little bit. Current law already provides a significant number of protections for the juvenile that will be eligible for life without parole. An offender must be 16 or older at the time of the crime, number one. Number two, the prosecutor must choose to pursue life without parole. 3, the prosecutor must prove, and a jury must unanimously agree, that the defendant not only committed the murder, but did so under special circumstances, making the crime even more heinous than usual, some of those types of crimes being just referred to. And then 4, the judge must agree. The judge must agree that the crime was so severe that individuals should not have the right to parole at any point. So we see it's a pretty high bar that's being set for this juvenile, a 16 or 17-year-old juvenile. Probably narrows the numbers quite a bit to some of the heinous crimes that do happen and some of the juveniles that are not sentenced under LWOP. So what we're doing here is opening the floodgates a little bit wider, already from what they are, thanks to AB 109 and some of the other measures taken by this legislature to make our streets even less safe in California. I don't think we've even seen more than the tip of the iceberg of what's coming down on the public safety and its lack of it for the citizens of this state. So this moves even more so in the wrong direction. Yes, we need to be compassionate in what we do in sentencing and looking at whatever this younger person might have done, but we already have that built into the system here. It's built in at the discretion of the judge, the jury, the prosecutor, all the way up the chain. And so this moves us into a more perilous direction for California. And so I have to ask your no vote.
Senator De Leon.
Thank you, Mr. President. Obviously, this is a very polemic and polarizing debate. and I can understand some of the angst within this group of legislators. A couple points I want to highlight here is that California has the worst record in the nation when it comes to racial disparity in the imposition of life without parole for juveniles. More specifically, in the state of California, African American youth are serving the sentence at a rate that is 18 times higher than that rate of other youth, specifically white youth in the state of California. And the rate for Latino youth in the state of California is 5 times higher. 85% of those who've been sentenced to LWOP, life without parole, are youth of color. 85%. 75% of those being in California, African Americans or Latinos. I want to try to bring some rationality and some saneness to this very polemic debate about these so-called little sociopaths. If you're a sociopath, or if you're a psychopath, a sociopath, someone who's narcissistic and lacks empathy, there is no sense of consequences, how to decipher what's good and what's not good. If you don't have a consciousness, you know, I can understand that issue completely. But these, not all, but some of these youth who've been sentenced to LWOP, for example, are young men, young knuckleheads who haven't thought things out, who have not matured, who perhaps were told, hey, I need you to give me a ride and take me down to the corner liquor store. And as a knucklehead, you take that individual down to the liquor store, only to find out when you were told to sit in the car and keep the car going, that the individual went up into the store and held someone up, and tragically and sadly took someone's life. You didn't know this. It wasn't premeditated. It was a dumb decision to do. No one excuses a dumb decision. Consequences must be paid, unquestionably. But 25 years to life, the possibility of no parole at all whatsoever for a dumb, stupid, horrific mistake. I think these are the type of individuals that the author of this measure is trying to use this law, if it becomes law, apply towards. These are individuals here, obviously the judge, the judicial branch will have the discretion. Clarify another point, the gates of the prisons aren't being opened, and a lot of these quote-unquote little psychopaths are being unloosed, or I should say released into society. A judge has to make a determination. A judge has to review the paperwork. A judge has to interview all of those individuals involved. The family's victim, the victim's family, I should say, the lawyers on both sides of the case, law enforcement, all individuals, prison guards, counselors, therapists, psychologists, psychiatrists, to get is an objective assessment on this individual. You know, regardless of socioeconomic strata of the color of your skin or the deck of cards you were born with, if there was abuse in the family, psychological, sexual, verbal, physical, if you are a cold-blooded psychopathic killer, I don't care who you are and where you come from. I don't want you on the streets, period. No questions asked. But what this is doing is trying to apply an objective assessment to a lot of other young men who've been caught up unnecessarily. And to perhaps use a sort of district attorney, DA, prosecutor, sort of as the stand-all. These individuals are very subjective in their application of the law as well, too. Yes, they're politicians who who are much more powerful than each and every one of us on the Senate floor. They can apply the law and they can send you to prison to life, or they can send you to the death penalty. They can apply the death penalty. So there is a subjective application when it comes to the law. If not so, these numbers here and the disparity of the application of LWOPs is grotesquely outstanding. That's why I believe you have the NAACP, books, not bars, the Ella Baker Center for Human Rights, the Children's Defense Fund, the Equal Justice Initiative Fund, among others, who are strongly supportive of this measure. This is a measure here not meant to politicize this situation, but rather take an objective instrument, not allowing folks to leave, but saying, let's just take a timeout and reassess this objectively. Let's look at the circumstances and interview all of the individuals, including the victim's family, and get a thorough understanding. It's a tough bill, no doubt about it, but you know what? We need to stand up and right the wrong. So with that, Mr. President, I stand for this measure.
Thank you. Senator Leno.
Thank you, Mr. President. The debate's been long. I will be short. We are certainly all welcome to our own opinion on this, and we each will have. It's a very emotional issue, but we're not allowed each our own facts. Quite simply, as already been stated, but just to reiterate it, this bill returns nobody to society. It does not shorten one sentence. It lets no one out of prison. Charles Manson was not a child when he committed and was convicted of a series of horrible murders. We're talking about children. And the testimony in policy committee over the many years that Senator Yee has put this bill forward have been very impactful. We heard the story of one young man, yes, convicted of first-degree murder. He was 16. He was seated in a getaway car. That's as close to the murder as he got. Now, should he go to prison? Certainly. Should he be 15 years in prison minimally? No one's going to argue that. This bill just allows for a relatively small number of circumstances where it should be revisited for a young person who has already served 15 years in prison to have that case reviewed by the very court that sentenced that young person to life without parole. And what will the outcome be? In some cases, maybe 25 years to life, so that this human being may have an opportunity at some redemption when it is appropriate. And that's for a court to figure out, the very court that imposed the initial sentence. I think this bill is very worthy of support.
Senator Steinberg.
Thank you. I appreciate, again, the quality of at least most of the debate here on the Senate floor. I just wanted to add my voice because I think it is important when members cast a vote on this subject that they are very clear on their motivation and their reason inside. I don't mean political motivation. I just mean why they feel the way they feel. And I've heard some say, well, this is not about those who oppose the bill. This is not about vengeance for me. It is about safety, and fair enough. But the real question then before us is, in my view, the following. Are children beyond redemption? If this isn't about vengeance, can the opposition argue convincingly that no child, 15, 20, 25, or 30 years or more after committing a horrible crime is not changed and might be safely released to society? Now, there have been some terms on the floor here that I didn't like. Little psychopath, mini Manson, and all that. Well, maybe. But maybe we're talking about a 16-year-old who turns 30 or 40 or 50 who is a completely different person, by virtue of finding God, by virtue of their own process, by virtue of their experiences in prison, by virtue of gaining an education, by virtue of getting help for a mental illness or a substance abuse problem, that person may be safe to return to society. So if it's not about vengeance, then what is it about? Because the burden here and the process, as has been pointed out, is pretty onerous for any individual to achieve release under this statute. You have to first go back to the sentencing court, the very sentencing court that sentenced the defendant to life without the possibility of parole. Then only if they say something dramatic has changed here does the case go to the parole board. And if the parole board says yes, they may say yes then, 15, 20, 25 years later. They may say yes, but let's wait another 10 years. And then, of course, there is the governor ultimately as well who can say no. Society, to me, I was always brought up in believing that society, that we're measured by our ability to show mercy, and compassion in the most difficult or egregious circumstances at times. And certainly, we all agree, and it should be clear, if somebody commits a heinous act, and there's really any doubt that they would be a danger in society, they ought not to get out. But the law must allow, always allow for the exception, because people are, in fact, capable of change and redemption. I urge an aye vote.
Senator Lowenthal.
Thank you, Mr. President. Question of the author.
Sure.
Without objection.
As I understand, we're talking about the person had to be under the age of 18, has to serve at least 15 years, has to meet certain criteria, show remorse, demonstrate rehabilitation. What I'm not clear of is what are the options for resentencing? Can you tell me what happens once they now meet these criteria, petition, the courts hear that petition, what options can be done at that time? Thank you.
So the options are as follows, that you have to, the individual has to serve at least 15 years in order to get any consideration of a hearing. You then petition to the court that sentenced you. Now, the court may, in fact, based on just the paper documents that you send in, determine that you're not eligible. And then that's it. You do have 3 tries. Then if you, in fact, go before the court that sentenced you, in that hearing, then you have to demonstrate that you've accepted responsibility. You develop some understanding, a remorse about what happened, taken some responsibility, demonstrated that you have a system of support to kind of help you move along in this particular understanding. So if, in fact, the court decides that we ought to relook at that sentence, then the court can, in fact, or change your sentence to 25 years to life.
To 25, so they...
25 years.
So the minimum that they can do is when you've served 15 years, you apply. They may decide, the courts, that first to hear the petition, and they can do that a couple of times over a period, 2 more times, I think 3 times total. And if they decide that you have met these criteria and they can then change your sentence, but the minimum amount of time that they could change it to would be 25 years to life.
The only authority they would have in this bill is, in fact, to change it from an LWOP to 25 years to life. Then, after 25 years, you can, in fact, petition the parole board for parole. But as we all know, it is extremely difficult for anyone to go through that particular process and get released.
And then the governor gets involved also at that point?
But mind you now, given the fact that you've petitioned the court originally for this particular change, you've established a level of performance and standard of behavior that is extraordinary. In order to be released on parole, I would imagine that you would then have to do even more to deserve that particular parole. And again, when you look at the data, individuals who are released on that 25 years to life, the statistics says that they don't re-offend. Because by the time you get out, if you look at the math of an individual in this particular situation, they will probably be 40, 50, 60 years old. And the likelihood of those individuals at that age to re-offend is very, very little. And that is the reason why, with this particular bill, we really have provided a balance between those individuals who ought to say, let's throw away the key, and others who say, let's give them a second chance.
Thank you for that complete answer.
Any further debate or discussion, members? Any further debate or discussion? Senator Yee, you may close.
Thank you very much, Mr. President. Let me just kind of summarize, I think, 2 points that have been raised by both the proponents and those individuals who oppose the bill. As I said, this is not a get-out-of-the-jail card at all. You have to serve 15 years before you are ever considered. And again, the petition goes back to the court that sentenced you. And with all the background and information about the particular individual, there's plenty of opportunity to make comparison as to whether or not the petition that is being submitted warrants a dramatic change or an assessment that there's a dramatic change in this particular individual. And again, after you get that particular change, you're still not out of jail, you're still not out of prison, you still have to then serve 25 years. And after 25 years, then you petition as to whether or not you will then get parole. And again, the percentage of cases where there's parole is very unlikely. And when you look at the data of individuals who, in fact, get out on 25 years to life, they tend not to reoffend. Let me just amplify a point that Senator De Leon and Senator Leno mentioned. There are many cases right now in prison where the individual who is charged with murder were not the shooter. I think Senator Leno said that there was a case in which a youngster just simply happened to be driving the car. And because of his rather, maybe lack of understanding about what was going on, his concrete thinking at that time as a youngster, he basically said to the prosecutor and said to the judge, I didn't do anything. I didn't kill anybody at all. In his mind, because he didn't shoot anybody, he ought not to be charged with murder. Murder to him means that I killed someone. If I didn't shoot someone, then how can I kill any individual? As adults, we all understand you need to take some responsibility. Even though you didn't shoot anybody, you were part of that act where you aided and abetted that particular death. And it is because of the lack of understanding, the thought processes of these young kids, that you have to understand that they don't comprehend what adults are talking about and the rules of how you handle cases as an adult. And so that was the problem of this particular youngster. And because he was rather recalcitrant on the part of the prosecutor, on the part of the judge, they threw the book at him, and he got an LWOP sentence. The shooter, interestingly, because he was a little older, figured out what the rules of the game might be in terms of dealing with the judge and the prosecutor, He pleaded guilty. He got a lighter sentence. He was the shooter, and he got a lighter sentence than the kid who basically drove away the getaway car, and he didn't, in fact, do the shooting. But he is now sitting in prison for the rest of his life without the possibility of parole. Those are the kinds of differences that we're talking about. You know, those individuals who are opposed to this particular bill may not vote for it, you know, talk about these horrible individuals. Some of them, when they go before a court, they probably won't get that second chance. But there are some individuals that may, in fact, deserve that second chance. We ought to give them that possibility. And so with that, urge an aye vote.
Alquist, aye. Anderson, no. Berryhill, Blakesley, no. Calderon, Canella, no. Corbett, aye. Correa, De Leon, aye. DeSaulnier, aye. Dutton, no. Emerson, Evans, aye. Fuller, no. Gaines, no. Hancock, aye. Herman, no. Hernandez, aye. Huff, Kehoe, aye. LaMalfa, no. Leno, aye. Tedlew, aye. Carol Liu, aye. Lowenthal, aye. Negrete McLeod, aye. Padilla, aye. Pavley, Price,
Aye.
aye. Rubio, no. Runner, no. Smidian, aye. Steinberg, aye. Strickland, no. Vargas, aye. Walters, no. Wolk, aye. Wright, aye. Wyland, no. Yee, Yee, aye. Correa, no. Emerson, no. Berryhill, no.
Ayes 21, no 16. The Assembly amendments are concurred in.